So apparently 10 rounds is the number that keeps us safe. Not 11, not 9, not 8, 10.
We have a major escalation in the Benson case where a court struck down the district's ban on magazines that hold more than 10 rounds.
Ninth Circuit Court of Appeals has overturned California's ban on high-capacity gun magazines, saying it violates the Second Amendment.
D.C.'s Court of Appeals rules the district's ban on some firearm magazines violates the Second Amendment.
The appeals court in Washington, D.C. has now officially struck down the magazine capacity limit law.
A federal appeals court just slapped down Washington, D.C.'s attempt to contain one of the most significant Second Amendment rulings we've seen in years. D.C. tried every tool in its legal arsenal to freeze this decision, fast-track a reversal, and strip it of its power before it could ripple across the country. The court looked at all of that and said no, not once, but multiple times in the same set of orders. What just happened here carries enormous weight, not just for this one case, but for magazine ban challenges happening right now in courts from coast to coast. Let me walk you through exactly what went down, why the court rejected DC's arguments, and what this means going forward. To fully understand the significance of what just happened, we need to step back and look at how we got here. The case at the center of all of this involves a man named Tyree Benson. Benson was convicted in Washington, D.C. on several firearms-related charges, including possession of a magazine that holds more than 10 rounds, which D.C. had banned. His case made its way up to the D.C. Court of Appeals, and that court delivered a ruling that sent shockwaves through the legal world. The court found that D.C.'s ban on magazines holding more than 10 rounds is a violation of the Second Amendment. That alone would have been a major headline. But the court went further. It didn't just strike down the magazine ban itself, it also vacated several of Benson's related convictions. Those included possession of an unregistered firearm, unlawful possession of ammunition, and carrying a pistol without a license. The reasoning was that those convictions were fundamentally tainted by the unconstitutional magazine ban. They were all interconnected, and once the foundation fell, the rest came down with it. That was a sweeping decision with potentially massive implications, and DC knew it immediately. After losing that ruling, DC moved fast. They filed a petition for what is called rehearing en banc. That means they wanted the full court, not just the three-judge panel that issued the original decision, to take another look at the case with the goal of reversing it. But they didn't stop there. Alongside that petition, DC filed a motion to expedite the entire rehearing process. They wanted the court to put this on a fast track to compress the timeline and get to a resolution as quickly as possible. On top of that, they filed yet another motion asking the court to suspend the precedential effect of the Benson ruling. In plain language, they wanted the court to essentially freeze the decision, to say that even though this ruling exists, no one can rely on it or cite it as binding law while the en banc petition is being considered. So DC was trying to do two things simultaneously. They wanted to slow down the impact of the ruling by freezing it in place, and they wanted to speed up the process of reversing it. Their justification for all of this was a claimed public safety emergency. DC argued that the Benson decision would cause magazines to flood into the district, that crime would surge, and that the ruling had created chaos on the ground that demanded immediate judicial intervention. And here is where we arrive at the development that just dropped. The court issued its orders, and it denied both of those motions. The motion to expedite the en banc rehearing was denied. The motion to suspend the precedential status of the Benson ruling was also denied. Those were the two most critical tools DC needed to contain this decision, and the court took both of them off the table. What this tells us is enormously significant. The court is not treating this situation as an emergency. There is no compressed timeline. There is no freeze on the ruling. The Benson decision stands as binding precedent right now, today, and it will continue to stand as binding precedent while the en banc petition works its way through the normal process. The court also issued a separate order that reinforces this approach. It gave the Benson side 14 days to file a response to DC's en banc petition. It also invited the United States government to file a response as well. Now, this is a detail worth pausing on. The federal government, under the current administration, has actually aligned with the pro-Second Amendment side in this case. So both Benson's legal team and the United States Department of Justice now have an opportunity to argue why the full court should not take this case up for en banc review, or at the very least, why the original ruling should not be reversed. The court also made a pointed statement in its order. It said that any extension of the 14-day deadline will only be granted under extraordinary circumstances. That language is deliberate. The court is signaling that it intends to follow a normal, orderly process. It is not going to rush things the way DC wanted, and it is not going to let anyone drag things out either. This is going to proceed on the court's timeline, not on DC's preferred schedule. Now, things get even more interesting when you look at what one of the judges wrote in a separate statement accompanying these orders. Judge Daly issued a statement that directly and forcefully pushes back against the narrative DC was trying to build. He walks through DC's claims about a public safety crisis and essentially dismantles them piece by piece. His first point is devastating to DC's position. He notes that the government itself had already stopped prosecuting magazine-related offenses more than 6 months before these motions were filed. 6 months. And during that entire 6-month window, there was no flood of prohibited magazines into the district. There was no spike in violent crime attributable to magazines. There was no meaningful change whatsoever in what was happening on the ground. The judge's conclusion is blunt and direct. There has been no change at all, and the claimed public safety emergency is overstated. He then takes on DC's argument that the Benson ruling will open the floodgates and cause a surge of these magazines into Washington, D.C. Again, he points to the evidence and finds nothing to support that claim. There is no data showing that is happening now, and there is no data showing it is about to happen. In fact, the judge highlights a statistic that cuts directly against DC's entire position. Between 2018 and 2022, nearly half of all firearms prosecutions in DC already involve magazines that hold more than 10 rounds. Think about what that means for a moment. DC has had this ban on the books for years, and yet roughly half of the gun cases coming through their courts involved the very magazines that were supposedly banned. The idea that the ban was actually keeping these magazines out of the district is, at best, highly questionable. The judge is essentially saying that the ban was not working as a practical matter, and the sky is falling narrative that DC is pushing does not match the reality on the ground. Judge Daly also raises a critical legal point that goes to the structural heart of this case. He explains that much of the confusion and enforcement that DC is complaining about is actually being caused by DC itself. Here is how that works. DC had a system where you were required to register firearms, but at the same time, DC refused to allow people to register firearms that were equipped with magazines holding more than 10 rounds. So if you owned a firearm that came standard with one of these magazines, you literally could not comply with the registration requirement. You were trapped. You could not register the gun because of the magazine, and then you could be prosecuted for having an unregistered gun. That is exactly what happened to Benson. The court makes it crystal clear that DC has the power to fix this problem immediately on its own without any court intervention. All DC has to do is change its own administrative policies to allow registration of these firearms. The fact that DC is instead running to the court and claiming an emergency when it could resolve much of the issue itself significantly undermines its credibility. The judge also calls out DC on something that might seem like a small procedural detail, but actually speaks volumes about the sincerity of DC's emergency claim. DC took 13 days to file its own en banc petition after the Benson ruling came down. 13 days. But then, in the same breath, DC turned around and asked the court to give the other side only 9 days to respond. If this were truly the 5-alarm emergency that DC claims it is, you would expect DC itself to have moved faster. Taking nearly 2 weeks to file your own petition and then demanding the other side respond in 9 days is not consistent with a genuine emergency. The judge sees right through this, and he makes that point clearly. Now, it is important to also look at the other side of this. There is a dissent that matters here. Chief Judge Blackburne-Rigsby would have granted the motion to expedite the en banc review. However, and this is a significant however, she would not have granted the motion to suspend the precedential effect of the ruling. So even the judge who disagreed with the majority on the speed issue still would not have frozen the ruling itself. Her reasoning for wanting expedited review centers on the idea that the Benson decision creates a circuit split. She points to other courts, including the Ninth Circuit and its decision in Duncan versus Bonta, as well as a prior DC decision in the Henson case that reached different conclusions about magazine bans. In her view, when courts are reaching contradictory results on the same constitutional question, that is something the full court should address sooner rather than later. She also echoes some of DC's public safety arguments, suggesting that magazines holding more than 10 rounds are commonly associated with unlawful activity and that the Benson ruling could create genuine risks for Washington, D.C. But despite those concerns, the majority held firm. Both motions were denied, and that denial speaks louder than almost anything else in this case right now. Even with arguments about public safety risks and a potential split between circuits, the court still does not see this as an emergency that warrants deviation from the normal process. The court is not panicking, it is not rushing, and it is certainly not willing to strip a binding constitutional ruling of its power based on speculative claims about what might happen. So where does all of this leave us? The en banc petition is still pending. That has not been resolved yet, and it may take some time before we know whether the full court will agree to rehear the case. The motion to expedite that process has been denied, so this will proceed on a normal timeline. The motion to suspend the ruling has been denied, which means the Benson decision remains fully operational binding precedent within the DC Circuit. Responses from both the Benson team and the United States government are due within 14 days, and the ruling itself continues to carry weight not just in DC but across the entire country. That last point is arguably the most important one. The Benson decision is already being cited and referenced in other major Second Amendment cases. It is relevant to the Duncan case that is currently pending before the Supreme Court. It is relevant to the Cheeseman case in the Third Circuit, which involves similar magazine capacity issues. It is relevant to multiple challenges in the Seventh Circuit dealing with assault weapons and magazine restrictions. The longer the Benson ruling stands as good law, the more influence it exerts on all of these other cases. That is precisely why DC was so desperate to contain it quickly, and that is precisely why the court's refusal to do so matters so much. When you step back and look at the full picture of what just happened, the trajectory is remarkable. A major federal appellate court struck down a long-standing magazine ban in the nation's capital on Second Amendment grounds. The government immediately tried to rush a reversal and freeze the decision before it could spread, and the court looked at those requests, evaluated the claimed emergency, and decided that none of it warranted extraordinary action. The ruling stands. The process continues at a normal pace, and the legal landscape for magazine ban challenges across the country just got significantly more favorable. As more developments come in on this case, and there will be more developments, we will break them down in detail. This story is far from over, but the direction it is heading right now is clear. That's it for today, folks. See you in the next video.